is... Sir, on your right side, but not as much right as previously.
Yes, my lord.
Over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power, or is this a judicial power, or is this an administrative/statutory power? Because 183 is ultimately a judicial power, because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power but an administrative power. So can Parliament whittle down? This is a question, please note.
Yes, it's noticeable, and in fact that is exactly, that will be exactly my purpose.
Please hear his lordship.
Sawal to sun le. Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out, in exercise of administrative power, anything that the committee feels, 3 judges, not the whole of the Supreme Court, but 3 judges, senior most respectable judges, but in the end just 3 judges, block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an...
And I will go even further than that.
And also a supplementary question connected to this. Earlier, the Justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
If I may add, there is a judgment of this court and the judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would recall reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
In fact,
Sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power. But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this is not a question of composition of benches. That is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
And
you don't have to answer.
No, I'm not answering.
Carry on.
I'm not answering.
The ordinary Chief Justice said you carry on with your submissions. Just note the question.
This thing, I will add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I am being condemned. I'm not being heard.
Who is
the party is not being heard.
Who is when you're using the word I? Who is the I here?
Litigant. The litigant. Because
एक सेकंड तहम्मुल the litigant, that leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm now asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter. You or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner, and I'm saying this thing that we brought this petition in the interest.
You got the answer. Now please proceed. I've got the answer.
I've got in the interest that the law should take its course. The Constitution must be upheld. And I'm also saying that I'm sure with such luminaries sitting there, the whole object is that, first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please. We are not going to platitudes.
I will not make a political speech.
Khwaja Sahab,
I'll refrain from that.
Just proceed with that.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify.
Is it your argument that Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
Yes, sir. 2 and 3 have to be read independently and separate.
Now, please.
2 an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I requested you please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very, very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
All right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because you would be left with no powers then.
We noted this down, and in fact, I will say that the Chief Justice powers will be whittled down. As if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in. And the latest one is, of course, 2000. I will continue. Let me continue. Let me continue.
Mr. Khwaja, I will add.
Then is a
Mr. Khwaja.
Yes, sir.
Right side. I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice. I think that's the moot question.
The answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is the Chief Justice and so many other judges.
will be sitting here till 12 o'clock.
I know that, sir.
So, आप जरा अपना argument करें. अभी तो हम section 3 पे पहुंचे.
Let me, on section 3, I will only say this thing, that this certainly is, the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, section 3 is. Now, next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5, or limiting it to 3, or why not 7, why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, it cannot less than 5. Then there's a question of appeal, and which is a very relevant point.
Khwaja Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship Did not, sir. I will not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. About how the benches are to be
आगे बढ़ते हैं.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your suggestion.
No, sir. I'm saying this thing that under the 1980 rules, their power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the parliament.
Okay, now let's proceed. We'll ask.
I'll argue on that. That is the point which needs consideration. 5 is appeal. Yes, Marisa.
On section 4.
Also.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी.
जी.
मैं इधर हूँ जी.
जी सर.
मैं बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है.
नहीं सर.
सुन लीजिए, सवाल तो सुन लें.
जी जी.
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है. ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है.
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं.
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है.
चलिए बस नोट कर लीजिए.
मैं नोट कर लिए. जब सुप्रीम कोर्ट
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता.
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो जाएगा.
I have worked with all of you, sir. I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए.
If I may,
problem nahi. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, sir.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself?
Yes.
Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right.